Welcome back to the Deep Dive. We're continuing our journey through the Manual of Patent Examining Procedure, the MPP.
Yep, the MPP.
Think of this whole series as, a way to decode the sometimes pretty dense language and complex rules of U.S. patent prosecution.
Especially when you're looking at international applications.
Exactly. We're trying to make it accessible.
Right. The MDP is the rule book, but our goal here is to translate it into something practical for you. Whether you're deep in prosecution, studying, or maybe just curious about how global innovation actually gets protected.
And today, we're zooming in, focusing on a very specific but actually really important detail in Chapter 1800. That's the chapter on the Patent Cooperation Treaty, the PCT.
Ah, yes, the PCT.
Our target today is MPP, Section 1820, Signature of Applicant.
Now, I know what you might be thinking. Signatures. Sounds a bit dry, maybe. Who needs to sign a line on a form?
Yeah. Seems basic.
But honestly, in the world of international patents, getting that signature right, it's fundamental. It's like the first gate your application needs to pass through.
Okay, so let's start at the beginning. What's the baseline rule for that initial international application request under the PCT? Who's supposed to sign it?
Okay, so the general principle, and this is laid out in PCT Rule 4.15, it's pretty straightforward on the surface. The request part of the international application must be signed by the applicant.
The applicant. Makes sense.
And the rule also says if you've got more than one applicant listed, then the general rule is that all of them need to sign.
Okay, so theory is multiple inventors, multiple signatures. Seems logical, right? Everyone with a stake signs off to get the ball rolling.
That's the idea.
But knowing the patent world, there's usually a but, isn't there? A nuance, an exception.
You absolutely nailed it. While that is the general rule, PCT Rule 26.2 BIS brings in a really critical, practical exception.
Okay, an exception.
And this exception, it's specifically for meeting the requirements of PCT Article 14.1.
Remind me, what's that part about?
Okay, think of Article 14.1 generally as the receiving office's first look, their initial check of the application's formal requirements.
Like ticking the boxes.
Sort of, yeah. They're checking if the basics are there to even give the application an international filing date. And Article 14.1ai, that specific part, deals with checking the signature requirement.
Got it. So Rule 26.2 BIS makes an exception just for that first check by the receiving office.
Exactly. And here's the exception. For the purpose of satisfying that specific formal check under Article 14ai, the request is considered, okay, it's sufficient if it's been signed by just one of the applicants.
Wait, hold on. So even if I have, say, 5 joint inventors listed as applicants, when I file that international application with the receiving office, like the USPTO, for example,
Yep.
They're initially just looking for one signature out of those 5.
That's precisely right. For that initial formality review, under that specific article, one applicant's signature is enough for the receiving office to move forward. And this is, a really significant practical help. Imagine trying to coordinate signatures from inventors or maybe assignees scattered all over the world just to get the filing date secured.
Oh, yeah, that could be a nightmare.
This exception makes that initial filing step much, much more manageable.
That is a huge practical difference.
Yes.
It really sounds like a rule designed to, grease the wheels and get the process started without unnecessary delays.
Definitely.
But does this single signature then satisfy all requirements everywhere down the road? Or is there another layer to this?
Good question. And that's where we'll see a really critical distinction pop up later. So while the receiving office is happy with one signature for their check under 14.1ai,
Okay.
the need for more signatures might actually come back later, specifically during the national phase. But yeah, we can circle back to that point.
Okay, noted. A potential future issue. So, for now, one signature gets you past the first hurdle at the receiving office. But this still raises the question, who actually counts as an applicant who can give that signature? Because that's not always just the inventor, right?
Absolutely not. The MPP, and it pulls from U.S. rules like 37 CFR 1.42 here, it clarifies who can be the applicant in different situations. The most obvious one, of course, is the inventor, or if there are several, all the joint inventors.
The person or people who actually came up with the invention.
Right, they're the sort of natural applicants.
Yeah.
But the rules cover other cases too, like if an inventor has passed away or is legally incapacitated,
Okay.
then their legal representative can step in and act as the applicant.
Makes sense. To manage their patent affairs.
Exactly. And there's another scenario involving omitted inventors. Sometimes, maybe through an error or some misunderstanding, a joint inventor might get left off the application initially. Yeah. So in that case, the other joint inventor or inventors who are listed can actually apply on behalf of themselves and also on behalf of the one who was missed.
Okay, so the system has ways to handle situations where not everyone is there or available right at the start. That's good?
Yes. It lets the process move forward while still trying to protect everyone's rights related to the invention. And importantly, an applicant can also be someone totally different from the inventor. Specifically, an assignee or an obligated assignee.
Meaning the company they work for?
Often, yes. Or any person or entity that can show they have a, quote, sufficient proprietary interest in the invention.
Right. This covers all those cases where the invention was made as part of a job and the company or maybe the university owns the rights.
Precisely. If the rights to the invention have been formally transferred or there is an obligation to transfer them from the inventor to, say, a company, then that company can be the applicant and they can sign the request.
Okay.
So, understanding who legally holds the rights is really key to figuring out who the proper applicant even is.
That makes total sense. The applicant isn't just the creative mind, but the legal owner of the rights.
Okay. And once we know who the applicant is, the sources also mention that the signature doesn't always have to come from that specific person or like the CEO of the company. It can come from their authorized agent.
Oh, very commonly, yes. In patent practice, it's totally standard for an applicant to appoint a registered patent practitioner, a patent attorney or agent to handle things for them.
Right.
And that agent can then sign documents on the applicant's behalf.
So the patent attorney who's actually filing the application, they can sign the request form.
Yes, as long as they're properly authorized by the applicant. Usually this is done through a power of attorney, although the exact requirements for proving that authority can sometimes vary a bit.
Okay. And are there specific rules for how that agent signs? Anything they need to include?
Absolutely.
Yeah.
Formalities matter here. When an agent signs, they must include their registration number.
This basically confirms they're a registered practitioner, allowed to represent applicants before the patent office.
Got it. Registration number check. What about the actual format of the signature? We hear about different types being okay in U.S. practice. Does the PCT follow suit?
Yes. The MPEP makes it clear that the general signature format rules under 37 CFR 1.4d apply to these international applications filed with the U.S. receiving office. And that rule allows both traditional handwritten signatures and also what we call S signatures.
S signatures, right. That's where you type your name between two forward slashes, like Jane Doe.
Exactly. Like John Smith. It's a handy method, especially for electronic filing. But there's a really crucial detail here.
Oh.
The S signature by itself, not enough. It must be accompanied by the printed name of the person signing, and that printed name needs to be placed either right next to or immediately underneath the S signature.
So John Smith, and then right below it, you type out John Smith.
Correct. That pairing is absolutely essential for the S signature to be considered valid. It connects that typed name thing to the actual identifiable person who's doing the signing.
Makes sense. Accountability. And what about purely electronic signatures?
Yeah.
The kind where you might click an accept or sign button in an online filing system. Are those allowed for PCT applications?
Yes. For international applications that are filed electronically, those kinds of electronic signatures are generally okay too. The key thing is they have to meet the specific technical requirements set by the particular receiving office you're filing with.
So each office might have its own system.
They might, or they might adhere to a kind of basic common standard that's recognized for electronic filings. The MPP points to MPP 9030 for more details on those electronic filing standards.
Okay, so whether it's actual ink, an S signature properly done, or a specific e-signature format, it needs to be clearly from the right person and follow the rule. It's all about verification, really.
Precisely. The system needs a reliable way to know who signed and that they did it in a valid way.
Let's switch gears just a bit. We talked about individuals signing and agents signing for them. What happens when the applicant isn't a person at all, but a big organization, like a corporation or a university? Who signs for them?
Yeah, that's a really common and important scenario, right? So many inventions come out of companies and universities these days. When the applicant is a legal entity like that, the individual person who signs the request has to have recognized authority to act on behalf of that entity, legally bind them, basically.
Like a C-suite executive.
Right.
President, CEO.
Yes, exactly. High-level officers who clearly have that kind of executive authority are the common examples given: president, CEO, that sort of thing. The rules mention that if the signer's title doesn't clearly show this authority, well, that can raise a flag.
Can you give an example? What kind of title might not be seen as clearly authoritative?
Well, the MPP mentions titles like general manager or maybe even in-house counsel. It depends on the specific organization and how their roles are defined, of course. But if someone with a title like that, maybe less obviously executive, signs, the receiving office might ask for separate proof.
Proof of what?
Proof, or maybe just a specific statement confirming that that person does actually have the authority to sign on behalf of the whole corporation or university for something like a patent application.
So you can't just grab any employee walking down the hall to sign it. It needs to be someone who's legally empowered to commit the company.
Exactly right. The office needs to be sure that the signature is legally binding on the applicant entity. Now, here's a really interesting twist that the MPP points out a place where national practices kind of influence these international procedures.
Oh, another nuance. Lay it on me.
Yeah. So while the U.S. receiving office might look closely at titles like manager or director for a U.S. applicant and maybe ask for that extra proof we just talked about.
Okay.
For foreign applicants, those same titles, manager, director, are often presumed to be enough to show signing authority. It's based on what's seen as typical in foreign business practices.
Well, that's fascinating. So a title that might cause a bit of a hiccup for a U.S. company could just sail through for a company based in, say, Germany or Japan, just based on this presumption about foreign titles.
Correct. The U.S. receiving office generally gives a certain amount of deference to what's considered standard practice for signing authority in other countries when they're dealing with foreign applicants.
Hello?
It's kind of a necessary bit of flexibility in a global system, but it's definitely a detail you need to be aware of, whether you're a U.S. company filing overseas or helping a foreign company file here.
Wow, yeah, that really underlines why knowing these details matters. Okay, so we know who should sign and how they should sign it. What if, despite all this, a signature is just missing? Someone forgets or doesn't get done right. Is the application dead in the water?
Thankfully, no, it's usually not fatal. A missing signature is generally treated as a correctable defect. And this falls under that same rule we mentioned earlier, PCT Article 14A, the one about the receiving office's formal checks.
Okay, correctable. Phew. How do you fix it? What's the process?
So the receiving office will send out a notice. They'll tell the applicant or their agent, hey, the signature's missing, and they'll set a deadline, a time limit for correction.
And how do you correct it?
You need to provide the missing signature within that time frame. Usually this is done by submitting a properly signed replacement page for the request form, or sometimes submitting something like a power of attorney can work if it authorizes someone else, like the agent, to sign for the applicant.
And going back to that single signature rule, if there were multiple applicants originally, is submitting a correction signed by just one of them enough to fix this defect?
For the U.S. receiving office, generally, yes. Because remember, their initial check under Article 14AI only required one signature in the first place.
Right.
So providing a correction with a signature from just one applicant or their authorized agent is typically going to be sufficient for the U.S. receiving office's purposes.
Okay, so the U.S. receiving office is satisfied. Crisis averted there. But does that mean the application is totally fine now in every single country the applicant might want protection in later on?
And here is that critical distinction I hinted at earlier. This is really important. While the receiving office, like the USPTO, is okay with that one signature to get things started, designated national offices in other countries, they are allowed, under PCT Rule 51A(b)(1)(a)(6), to still insist on getting signatures from all the applicants when the application enters the national phase in their country, if their own national laws require it.
So the initial leniency you get at the filing stage with the receiving office doesn't automatically carry over to every single country down the line.
Exactly.
A specific country could look at that application later, maybe years later, and say, hang on, our law says all three inventors need to sign this, even if the USPTO didn't demand it up front.
That's precisely what can happen. They can use that PCT Rule 51(b)(1)(a) to basically say, You need to meet our stricter national signature requirements now.
Wow.
So this means, while you might successfully get your international filing date with just one signature, you could definitely face requirements later on to get those additional signatures, or maybe proof that the one person had authority to sign for everyone when you actually try to enter the national phase in various countries.
That is a really, really important point. That could definitely trip people up if we aren't expecting it. It means you might be scrambling to get those extra signatures months or even years after the initial filing.
It's a procedural detail, sure, but it can have potentially significant consequences, delays, costs, maybe even problems securing rights if you don't anticipate it. It just highlights why you need to understand the rules at both stages, the international filing stage and the national phase entry stage.
Man, this deep dive into just one section, MPP 1820, has really pulled out a lot more complexity than just sign on the dotted line. Why is getting this level of detail right so critical for someone trying to navigate the patent system? It seems like such a small thing, a signature.
Oh, it's absolutely not a small thing in practice. Understanding these specific signature requirements, who counts as an applicant, who can sign for a company, the exact formats needed like for S signatures, and especially that difference in requirements between the receiving office and the later national offices, it's all crucial for successfully filing international applications.
Just avoiding getting rejected right at the start, I guess.
Well, yes, definitely avoiding delays or even rejection by the receiving office. But it's more than that. It's about avoiding procedural roadblocks later on. Roadblocks that could potentially put your application at risk in certain countries, or at least cost you a lot of time and money to fix. Getting these details right from the beginning helps ensure your application can move as smoothly as possible through what is, let's face it, a pretty complex global patent system. It's really about mastering the formalities to protect the actual substance, your invention.
It really sounds like paying attention to this kind of, administrative detail is almost as important as getting the technical description of the invention or the claims drafted perfectly.
Without a shadow of a doubt, you could have the most brilliant, groundbreaking invention described perfectly. But if you stumble on the procedural requirements, like getting the right signatures from the right people in the right format at the right time, your application can still hit major problems.
That's a really powerful point. Okay, so let's try a quick recap of our deep dive into MPP section 1820 today. We started with the general rule. All applicants usually need to sign the PCT request.
Right, a baseline.
But then we hit that crucial exception. Only one signature is actually needed for the receiving office's initial check under Article 14(1)AI.
The big practical time saver.
We clarified who can be an applicant, not just inventors, but also legal reps, other inventors signing for omitted ones, and assignees like companies.
Yep, the legal rights holders.
We covered the rules for agent signing, including needing that registration number, and the specifics of S signatures needing the printed name, plus electronic formats.
Formalities matter.
We dug into the complexities of signing for corporations and universities, needing clear authority, and noted that really interesting difference in how foreign entity titles like manager are often presumed sufficient.
The international nuance.
And finally, we talked about how missing signatures are correctable defects, but, and this is the big takeaway for later national office, might still demand signatures from all applicants during the national phase under their own laws.
That crucial distinction, yeah. A lot packed into just one section. It really shows how much detailed procedure sits underneath the whole international patent system.
It absolutely does. And before we wrap this up, we want to give a special thank you to Mike Shepard. He's the creative director who helps organize and bring this entire MPP audio series together.
Yes, definitely appreciate his work in helping make this complex stuff a bit more accessible.
Agreed. And now, the important disclaimer.
This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only, and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.
Right. And finally, maybe just a little something for you, the listener, to think about, based purely on what we've discussed from this section. Consider how paying close attention to these very specific formal requirements, like the exact format of an S signature or the job title of the person signing for a company, or remembering that difference between what the receiving office needs versus what a national office might demand later.
Yep.
Consider how getting those details right can be just as critical, genuinely just as critical, to the ultimate success of getting your international patent protection as the actual technical brilliance or novelty of the invention itself.
Wow.
It just really hammers home how vital procedural diligence is when you're trying to navigate these complicated global legal systems.
A great final thought. It's a reminder that the road to protecting innovation is definitely paved with careful attention to the rules. Thanks for joining us for this deep dive.
Always a pleasure digging into these details with you.